What if the next time you get pulled over, one simple decision could mean the difference between protecting your rights and accidentally waiving them? The Supreme Court just issued a landmark ruling that changes everything about how you should handle traffic stops, and the vast majority of Americans have no idea what's at stake. This isn't about politics or polarization. This is about a concrete legal reality that could affect you, your family, and everyone you know the moment you turn your car key. By the end of this video, you will understand exactly what the court decided, why it matters in your actual daily life, and precisely what you should do when those red and blue lights appear in your rearview mirror. Every year, roughly 20 million Americans get pulled over by police during traffic stops. That's more than 1 out of every 15 adults in the country, happening over and over again, day after day, in every city and rural road across the nation. Most of these stops are routine. A taillight out, speeding by a few miles per hour, a registration that's expired by a month. But here's what the Supreme Court quietly recognized in a decision that barely made the evening news. These routine moments carry extraordinary legal weight. When an officer approaches your car and asks you to roll down your window, you are standing at a crossroads between your constitutional protections and your actual freedom in that moment. The ruling centers on what happens when you comply with a police request to lower your window during a traffic stop. Lower courts had been split on this issue for years, with some judges saying that rolling down your window was a neutral act with no legal significance, while others argued it could be interpreted as consent to search or as a waiver of certain protections. The Supreme Court stepped in and said, essentially, that context is everything. The court made clear that when an officer asks you to roll your window down, that request operates in a legal gray zone where the stakes are higher than most people realize. Here's what most people don't understand about this ruling. When you roll down your window, you are doing something physically that changes the legal dynamic of the encounter. Police can now use the fact that you complied with the window request as one piece of evidence that you were cooperating, that you had nothing to hide, or even that you implied consent for closer inspection. The court didn't create a bright-line rule that rolling down your window equals consent, but it also didn't protect you as strongly as many people assumed it would. The middle ground the court carved out means that what you do in that moment matters more than most legal experts had previously advised. Think about what this means for a second. Imagine you are driving home from work, maybe you're tired, maybe you're running late, and suddenly those lights flash behind you. You pull over and the officer walks up to your car. In that instant, your brain is probably thinking about the ticket you might get, whether your registration is actually up to date, how much this is going to cost you. You probably aren't thinking about constitutional law. But the officer is trained to think about exactly that. The officer knows that whatever you do next will be part of an official record, part of a legal encounter that could be scrutinized later if something more serious develops. What the court said is that when you roll your window down, you are creating a factual record of cooperation that officers can point to in subsequent legal proceedings. Even if you didn't say anything incriminating, even if you didn't give permission for a search, the simple act of lowering your window has been treated by some lower courts as evidence of a cooperative mindset. The Supreme Court declined to overturn those lower court rulings, which means the legal landscape remains complicated, and the safest path forward is something every driver needs to understand. If you're finding this breakdown useful, subscribe now and turn on notifications. We track these legal developments in real time, and the next Supreme Court ruling on this topic could change the entire picture of what your rights actually are. The court is expected to hear more cases on traffic stop procedures in the coming term, and the decisions that come next will build on what was just decided. Staying informed means you'll know exactly how to protect yourself before the next ruling comes down. Now let's go deeper into what's really at stake here and why this ruling matters so much more than most people realize. The constitutional foundation for this case traces back to the Fourth Amendment, which protects against unreasonable searches and seizures. That amendment was written in the 1700s, long before cars existed, long before traffic stops were a thing, and courts have spent more than a century trying to apply those original protections to modern situations that the founders never could have imagined. When the Supreme Court earlier ruled that police can approach a car during a traffic stop without a warrant, they created a framework where the car itself became a kind of zone where privacy expectations are reduced compared to your home. But that reduction doesn't mean your rights disappear entirely. The court has consistently held that a traffic stop is a seizure under the law, which means your constitutional protections are triggered the moment an officer pulls you over. The question has always been how far those protections extend and what actions by the driver might be interpreted as a waiver or modification of those protections. Rolling down your window falls into that murky middle ground, and the Supreme Court's decision to let the current split remain means that your legal exposure depends heavily on which state you are in, which judge hears your case, and which officer stopped you in the first place. Here's the uncomfortable truth that most legal commentators are glossing over. The court didn't actually protect you. They gave you a framework, but they put the burden on you as the driver to understand the legal consequences of your actions in a moment when you are most likely not thinking clearly. Traffic stops are inherently stressful. Your cortisol levels spike, your heart rate increases, and your ability to process complex legal information drops significantly. The court knows this, but they ruled anyway that the burden falls on you. That means your preparation for this moment has to happen before you ever get pulled over. What should you actually do when an officer asks you to roll down your window? The safest answer, based on the Supreme Court's ruling and the legal principles underlying it, is to keep your window up until you have clearly understood what the officer is asking and why. You can lower the window just enough to speak with the officer, maybe 3 or 4 inches, which allows you to communicate without creating the same legal footprint as a full window roll down. This isn't about being difficult or disrespectful. Officers are doing their job, and you can be polite and cooperative while still protecting yourself legally. But wait, because here's what no one is telling you about this situation. There is a counter-argument from law enforcement officials who say that requiring people to keep windows rolled up creates safety risks. Officers need to be able to see into the vehicle, need to be able to communicate clearly, and need to be able to react quickly if something goes wrong. Some police training materials specifically advise officers to request window roll downs as a safety measure, not as a legal tactic. This creates a genuine tension between officer safety and driver rights that the court has not fully resolved. The legal argument on the other side says that if an officer has genuine safety concerns, they can articulate those concerns specifically. An officer who says, "I need you to lower your window so I can communicate with you more clearly," is making a different kind of request than an officer who simply says, "Roll down your window." The Supreme Court's framework, while not perfectly clear, does suggest that the specificity of the officer's request and the context of the situation can affect how your response is interpreted legally. A vague request for window roll down might carry different legal weight than a specific articulation of why the officer needs the window lowered. What does this mean for you in practical terms? First, you need to understand that you have the right to ask why an officer is making a request before you comply with it. You can say something like, "Officer, I understand. Could I ask why you'd like me to lower the window?" This question is polite, it is not confrontational, and it buys you a few seconds to process what is happening. Second, you need to understand that any compliance you provide can be documented. The officer's body camera is recording. Your response is being noted. Whatever you do becomes part of the official record that could be used in court later. Share your perspective in the comments below. Have you ever been in a situation where you weren't sure how to respond to an officer's request during a traffic stop? Your experience and your thoughts help us all understand this topic from different angles. While you're thinking about that, consider this next piece of the puzzle, because what I'm about to tell you might change how you think about every traffic stop you have ever been part of. The Supreme Court ruling also has implications that extend far beyond the simple act of rolling down a window. Consider what happens when an officer asks to search your car. If you have already rolled down your window, if you have already been cooperative in that small way, the argument that you are a non-cooperative or suspicious person becomes harder to make. Defense attorneys have used window roll-down compliance as part of a broader narrative about consent, about the totality of circumstances, and about what a reasonable person would have understood the officer's request to mean. Now that the Supreme Court has let those arguments stand, your small choices during a traffic stop matter more than ever. Here's the scenario that keeps coming up in legal discussions after this ruling. You get pulled over. You roll down your window fully, maybe because you are nervous, maybe because you want to show you have nothing to hide. The officer sees something in the car that catches their attention, maybe a bag in the back seat, maybe a container in the console. The officer asks if they can search the vehicle. You say no, but the officer notes that you rolled down your window, that you were cooperative in that earlier interaction, and uses that as part of their justification for a more intensive investigation. This is where the legal ground gets shaky, and the Supreme Court has essentially said that this chain of events is not automatically unconstitutional. Does this change how you think about traffic stops? I want you to really sit with that question for a moment, because your answer determines how you will respond the next time those lights appear behind you. The historical parallel that legal scholars keep drawing is the evolution of Miranda rights. When Miranda versus Arizona was decided in 1966, many people assumed that cops would simply read everyone their rights and everything would be clear. What actually happened was decades of litigation about what constitutes a waiver, what constitutes compulsion, and when exactly rights attach. The window roll-down issue is following a similar trajectory, with the Supreme Court establishing a framework that will take years to fully flesh out through lower court decisions and future rulings. What makes this especially complicated is that different states have been treating this issue differently. Some state courts have ruled strongly in favor of driver privacy, saying that a window roll-down is meaningless as a matter of law. Other state courts have allowed prosecutors to use window roll down as evidence in certain circumstances. The Supreme Court's decision to let this split stand means that your legal exposure depends on geography in a way that many people find frustrating. The same action could carry very different consequences depending on which state you are in when it happens. For ordinary people, this means something very concrete. You cannot assume that your rights are the same everywhere. You cannot assume that what worked for your friend in another state will work for you. You need to understand the legal landscape of your specific state, and you need to be prepared to make quick decisions in a high-stress environment with incomplete information. That is a lot to ask of regular people who are just trying to get from point A to point B. What can you actually do to protect yourself? Here are 3 specific steps you can take right now that will make a difference the next time you get pulled over. First, memorize your state's specific laws on traffic stops and searches. Many states have published guides on what you are and are not required to do during a traffic encounter. This information is often available for free through public defender offices or legal aid organizations. Second, practice what you will say if an officer asks for something that could affect your rights. A simple phrase like, "I want to understand the legal basis for that request before I respond," gives you time and documents your intent to cooperate without waiving your rights. Third, if you are ever in a situation where you feel your rights have been violated, write down everything you remember immediately while the details are fresh. Names, badge numbers, time, location, what was said, what was requested, what you did in response. This documentation can be crucial if you need to file a complaint or contest a charge later. The stakes here are higher than a simple ticket. A traffic stop can escalate into a vehicle search, an arrest, a criminal charge, or worse. Every year, thousands of people find themselves in legal trouble not because they committed a crime, but because they didn't understand what their actions during a routine stop might be interpreted to mean. The Supreme Court has just made that danger more real by refusing to protect people who roll down their windows, even as a seemingly innocent gesture of cooperation. But here's where I want to leave you with something actionable. Watch for these 3 specific indicators in the news this week and next. First, monitor whether any states announce changes to their police training procedures in light of this ruling. If a state updates its training to tell officers how to request window roll-downs, that will signal how seriously the ruling is being taken. Second, watch for any challenges to this ruling working their way through lower courts. Legal challenges that might eventually reach the Supreme Court again often start as civil rights lawsuits, and tracking those cases tells you where the law is headed. Third, pay attention to any public defender or civil liberties organization that publishes guidance on this issue for your state. Those organizations are on the front lines, and their guidance will be the most practical and up-to-date. The bottom line is this. The Supreme Court has just made your choices during a traffic stop legally more significant than most people realize. When an officer asks you to roll down your window, that request is not just a matter of convenience or communication. It is a legal moment with consequences that could follow you for months or years if the stop leads to something more serious. You deserve to know your rights, and you deserve to be prepared. Subscribe for our next deep dive, because we are already tracking the next development in this story, and the next update could change everything you thought you knew about protecting yourself during a traffic stop. The law is always evolving, and the only way to stay ahead of it is to stay informed.